Good morning, everyone. Today we are talking about the Rule 9610, the rule which impacted a lot of Indian exporters and importers, and how this decision of the Bombay High Court would help thousands of Indian exporters and importers. And before we start, we will tell you that this decision of the Bombay High Court, which we were arguing not only before Bombay High Court, but we were the first one to file the writ petition even before Gujarat High Court, in which Gujarat High Court has passed this decision in case of Cosmo Films versus Union of India. The constitutionality was addressed by Gujarat High Court and was held to be constitutionally valid. But then thereafter, the review was filed, and Gujarat High Court had changed in this review petition its earlier decision, which we were glad we could do it for the industry. As this petition was present before several courts, yesterday Bombay High Court has also pronounced the decision where we were leading the arguments for several petitioners, and we were the first one in Bombay High Court to file this for Yasho India. The controversy now has been settled by two courts, and the controversy which has been settled very clearly provides that these show cause notices which were issued must be dropped. The orders which have been issued must be quashed. And hence, to summarize this, there would not be any tax implications. There will be no tax recoveries. There will not be any interest implications. Any amount of tax or interest which has been paid during the course of the investigation or thereafter, or the pre-import, deposit which has been made during investigation or during appeals or the adjustments of these amounts which have happened, becomes refundable, comes back to the exporters. We are getting a lot of these queries about, and before we go into that, we will address some of these queries which we have been receiving. The first one is it necessary for us to file an application to claim a refund of the interest paid on IGST? Yes. It will now be very important for you to file the application to claim the refund of the interest, any interest or tax amount, or the amount paid during investigation, or the pre-deposit which has been paid now comes back. The best mechanism is to move this application as fast as possible. Uh, don't wait for the timelines for submitting such an application. You must file this as soon as possible, because as we speak, the decision of the court is in our favor. And tomorrow, we do not know whether the revenue would go and file an SLP against this order of Bombay High Court, or how the Supreme Court would even take into consideration about the order passed by Gujarat High Court. But today, as there is no stay by the revenue, this amount becomes payable, and the refund must be filed as soon as possible, possibly by Monday, if not tomorrow. The other question which is coming is, can we recognize the IGST interest refund as income in our books? So, from the accounting perspective, the amount which now comes to you, because initially if you would have debited that or treated that as an expense, the reversal or the contra entry happens, and yes, this interest must be recorded as receivable from the GST department and must be treated as income. The moment this comes into your balance sheet, even the contingent liabilities which were addressed with respect to these issues must be appropriately disclosed and disclosure must be made. The next question which is coming is that should we make an intimation disclosure to the stock exchanges? So for these listed companies, they will have to they will have to uh, file this intimation, and they will have to inform, because this is a material change. The court has now pronounced this decision. The contingency or the liabilities with respect to the disclosures, including the show cause notices, the orders, and whenever such of these things happen, must be informed to the stock exchange, because this is the final order. This is not an interim order. It becomes all the more important for the exporters to disclose it when they are listed to the stock exchange. Now, let us go to the aspect that why this decision is very, very important. And at this stage, we must understand that today India is having a tariff war. And even if we see the GST Council's 56th Council recommendations, lot of this rate rationalization has happened. While the rate rationalization or these changes with respect to the exporters were always on the card for the GST Council and for the government to implement, I think in terms of timing, the decision of this Bombay High Court is very, very relevant, because the exporters will get this relief in terms of the working capital blockages, the litigation cost, and all of this from the business confidence and boost purpose. This is an amazing decision for the Indian exporters. Now, let us also understand, before we go on to the issues framed, that the intention of the GST Council was always to remove this 9610. And what is this 9610? You must watch our earlier videos also, which we had released subsequent to the decision of the Gujarat High Court, which we had argued in case of the review in case of Cosmo Films and other petitioners. You must watch that video to go into details of this controversy. But in simple words, this controversy is through a rule which we felt was not there in the statute. And this rule provided that when an Indian importer takes benefit of one of these schemes which are prescribed there by law, for instance, the advance authorization scheme, you take the benefit of the advance authorization scheme to procure these procurements, the imports, duty free. Then the two options which are prescribed to you under the statute, the rebate option and the refund option. The rebate option is basically where you pay tax on the output side utilizing your credits. It is more convenient and simpler one. And the other one is with respect to the refund of unutilized credits which you take. So the rule provided for a restriction that you would not be eligible to the rebate option. It seemed very illogical that why to an Indian exporter, out of the two options which are prescribed under the statute, one must be denied. In about more than 50 of these petitions, which we have argued in different litigations, which we are doing, the question which has been asked always has been whether there is double benefit to the Indian exporter. We have demonstrated both by way of illustration and by way of actual numbers that the Indian exporters in these circumstances had never taken or claim the double benefit. The benefit is only with respect to the exemption, either in terms of the exemption, and when the rebate option is claimed, that amount does not come to the credit ledger, and hence the rebate amount also reduces. So we've been giving illustrations, we've been using actual numbers for exporters to address this issue of double benefit. So the GST Council also recognized, and when we had filed, in fact, the first writ on this in Gujarat, and we were also the first ones to file it in Bombay. Lot of people, the critics is always there that this would not sustain. There is a rule which is already there. But as the first mover, we were very careful. We always welcome critics. We thought that, let people say what they want to say. But we were very clear that this benefit has to come to the Indian importers and exporters in the most pragmatic way. A lot of recommendations also went to the North Block, and I would want to thank Honorable Finance Minister. She, in the GST Council meeting, well recognized this problem to the Indian exporters and amended this Rule 9610 by way of omission. Now, when this omission happened, then it was very clear at that very moment that GST Council would want to give this benefit to the Indian exporters. They recognize this problem. But I think the major issue was with the executive action, because either these show cause notices were issued, the orders were issued, the appeals were filed, more than 1,000 such litigation were happening all across the country. And this was happening in spite of the omission made by the GST Council, because GST is a big reform. It may not happen that everything could come into place, at the word go. But GST Council, in all its wisdom, thought it appropriate to omit this, and this omission happened, especially after Gujarat High Court, in its review, which we argued before Gujarat High Court, addressed all of those 8 points which were left unaddressed in the first round of litigation in Cosmo Films case. So when we had argued Cosmo Films case before the Gujarat High Court at that time, and at the later stage, there were various issues with respect to the same date, retrospectivity, even if it is constitutional, then how it would impact. And all of these changes were then addressed in the review which was heard by Gujarat High Court. Now, why that review was also for a reason that not only addressed the retrospective issue, that not only addressed that what must happen in different situations, but it gave certainty to industry. It provided that certainty to provide very clearly that these transactions must not lead to a burden to the exporters. And hence that Gujarat High Court order was very important. And why that Gujarat High Court order was also important was because somewhere GST Council also recognized that this will lead to a direct brunt on the Indian exporters. And hence, corrective measures were taken to make these changes in January of 2024. The intention of the GST Council was always to provide this benefit. Having said that, subsequent to the review of Cosmo Films, the GST Council also realized that this may somewhere lead to burden on the exporters. And hence, to completely solve the problem, omitted that Rule 9610. Subsequent to the omission, the show cause notices and the orders in origin which were pending before several authorities, we submitted that now this has been omitted and there is no saving clause. And I will come to even Section 6 of the General Clauses Act. We argued that Section 6 of the General Clauses Act comes into play. This has been omitted or deleted. without a saving provision, and hence any demands which are there even for the prior period could not sustain. Interestingly, in the second batch of the petition before Gujarat High Court, Cosmo was already decided by that time when these petitions came. Gujarat High Court addressed this issue, and yesterday Bombay High Court, in all fairness, in a speaking order, has gone into these details, that why Section 6 of the General Clauses Act applies and how the benefit would come to the Indian exporters, why these show cause notices must be quashed, why these orders must be quashed, why appeals must be dropped, and how and in what form all money must be refunded to the taxpayers, which was paid either during the time of investigation or the pre-deposit amount for which you will have to file the refund claim. Now, let us quickly go to the issues which have been framed by the Honorable Bombay High Court, because these issues are very important because it addresses the important aspects of the entire controversy. So the first aspect was whether the impugned Rule 9610 is ultra vires the CGST Act or otherwise unconstitutional and void. That was the first issue. Because when these petitions were filed before the court, at that point of time, the constitutionality was under challenge, because by that time, the amendment by way of deletion or omission of Rule 9610 was not on the card. That happened only in January of 2024. So that was on the constitutionality was the first question, and I will explain how the court has addressed that. The legal effect of omission of the impugned rules with a notification dated 8th October 2024 without any protection of Section 6 of the General Clauses Act or the Savings Clause in the rules or the Parent Act as contended by us on all the proceedings and other orders. So the question was that what is the legal effect of this omission of Rule 9610? Whether any of these impugned orders could be regarded as transactions passed and closed. So whether this omission would lead to quashing of these show cause notices or the orders. Whether Section 6 of the General Clauses Act saves the impugned pending proceedings or orders. So if there is already something pending before the authorities, what would happen to that? And the answer clearly is that all of those have been quashed. So exporters have a reason to cheer, but the court has gone into those details that the past transactions must also be quashed. Secondly, the General Clauses Act Section 6 would apply, and I would come on to the constitutionality in a while. Whether as contended by the respondents, Section 6 of the General Clauses Act saves the impugned pending proceedings or orders, and the answer is that it would not save. The past orders and show cause notices will have to be quashed. Whether Section 6 of the General Clauses Act applies to the omission or repeal of the impugned rules, because the 24 amendment rules are enacted by exercising the powers under Section 164 of the CGST Act, and therefore the rules qualified to be regarded as Central Act for at least for the purpose of Section 6 of the General Clauses Act. So the entire controversy was with respect to the applicability of this General Clauses Act, which the court has addressed in the most pragmatic manner. Whether the provisions of Section 6 of the General Clauses Act are attracted to the present omission or repeal of the impugned rules, given the provisions of Section 174, subsection 3 of the CGST Act, and some part of the language is common in 174 and Section 6 of the General Clauses Act, and we'll come to that. Whether Clause 1 of 1-2 of the notification dated 8th October 2024 purporting to give prospective effect to the omission or repeal of the impugned rules saves all pending proceedings commenced before 8th October 2024. That was another question. whether as contended by the respondents, the pending proceedings as on the date of omission or repeal of the impugned rule stand saved by virtue of section 166 of the CGST Act. So these were the questions which were framed by the court. Now, the important aspects which we must, highlight today uh, is with respect to what happens to the constitutionality question, because that was the most fundamental question before the court right from day one, right from the first petition which we had filed before the Gujarat High Court in case of Cosmo Films, the review which happened with respect to the Cosmo Films, and of course from the first petition which we had filed even before Bombay High Court in case of Yasho, and thereafter a lot of these petitions were filed. The moot point or the controversy raised at that point was, of course, on the constitutionality. But keeping in mind the changes which have happened with respect to the deletion or omission of Rule 9610, the things changed. The Section 6 of the General Clauses Act comes into play. And the question, accordingly, with respect to the constitutionality, has been addressed like this. And according to the court, if the petition can be disposed of on any other issue by granting at least substantially the relief the petitioner seeks without examining the constitutional validity of a statutory provision or even the rules made thereunder, then the constitutional court should not rush to examine and decide on the issue of constitutional validity merely because it has the power to do so. So the court felt that this decision, because of the General Clauses Act and Section 6, would certainly be extended subsequent to the omission to the exporters, and hence the aspect with respect to the constitutionality of that Rule 9610 may just be academic right now. And hence the court was satisfied very clearly that the petitioners are entitled to succeed on the ground that this is the case of omission or repeal of the impugned rules without any savings clause to protect the pending proceedings. The court was satisfied that provisions of Section 6 of the General Clauses Act are not attracted, and therefore the provisions of general are not, and therefore relying upon these provisions, the pending proceedings can claim no immunity or protection. Therefore, it is quite unnecessary to determine the issue of the constitutional validity. So basically, Section 6 of the General Clauses Act came into play. The court felt that there is no need to examine the constitutional validity. Reading the language of the General Clauses Act, Section 6, the benefit after the omission must be and can be extended to the Indian exporters, and that in itself must be given without addressing on the constitutionality. The court also recorded the controversies regarding the constitutionality of 9610, which is not significantly different from Rule 89 4B of the CGST rules. The first rule applies to exports and the second to imports. Both the rules provide for certain safeguards to ensure that there is no overlap between the taxes and refunds regarding specific exports and imports. The court also very clearly highlighted that the decision of the Kerala High Court, the respondents were not able to make any statement with respect to those decisions, and hence the benefit must be extended to the petitioners in this case. And on the aspect of constitutionality, the court very clearly said that they do not propose to examine the issue of constitutionality of 9610 of the CGST rules. So now the court went into the legal effect of these omissions which happened, omission or repeal of the impugned rules without protection of any saving clause. And I think for us, what is most important is to examine Section 6 of the General Clauses Act and also see how it impacts us. Now, I will read Section 6 of the General Clauses Act. because the court addressed this issue whether Section 6 of the General Clauses Act is applicable and saves the pending proceedings. Now, Section 6 reads as follows: Effect of repeal. When this act or any central act or regulation made after the commencement of this act repeals any enactment made or hereafter to be made, then, unless a different intention appears, the repeal shall not. So, if repeal has happened, the repeal shall not revive anything not in force or existing at the time at which the repeal takes place. So, if 9610 has been repealed from a specific date due to the provisions of Section 6 of the General Clauses Act, the repeal shall not revive anything not in force or existing at the time at which the repeal takes place. The repeal shall not affect the previous operation of any enactment so repealed or anything duly done or suffered thereunder. The repeal shall not, and this is important, affect any right, privilege, obligation, or liability acquired, accrued, or incurred under any enactment so repealed. So, this repeal has happened. It may have led to some sort of an effect on any right or obligation, but the language used is that the repeal shall not affect any right, privilege, or liability acquired, accrued, or incurred under any enactment so repealed. So now 9610 has been repealed. If that has been repealed, Section 6 of the General Clauses Act comes into play. And that's what we've been arguing before before different authorities, where these show cause notices and these orders were pending. That Section 6 comes into play, because Section 6 comes into play now, the repeal has happened, and even the past transactions get covered, and you must drop these show cause notices and orders. Show cause notices if you filed in a reply to that show cause, or in appeal if the order has already been passed, with all consequential relief, including pre-deposit which has been made to file an appeal. Interestingly, in several of these cases, when the amount of pre-deposit has been paid using credit, we have also got the favorable order from the Supreme Court now, which is settled, that you could use that credit to make that pre-deposit. Now, all of that money comes back, and hence we must immediately file the refund claims. So, how the court has concluded? The court has said that everything now is to be quashed, therefore leaving aside the cases where the proceedings were commenced, prosecuted and brought to a finality before the repeal. No proceedings under the repealed statute can be commenced or continued after the repeal. So, tomorrow it cannot happen that you issue me one more show cause notice. Secondly, it cannot continue after the repeal. The show cause notice cannot continue after the repeal. And the court was very clear that the review of these rules make it clear that they are not purely procedural but impact substantive rights of the parties. And this is very important finding. It impacts substantive rights of the findings. Therefore, the removal or repeal of Rule 9610 would essentially erase these rules from existence as if they had never been enacted or passed, and they should be regarded as provisions that never existed except in relation to transactions past and closed. So it is very, very clear in terms of these findings. There were a lot of arguments which were raised by the respondent with respect to Section 6 of the General Clauses Act and the applicability of that, which the court has addressed. And I would not make this video long, you know, to address that. But I think one important argument which must be noted is that even Rule 1, Sub-Rule 2 of the 2024 amendment rules was so worded to avoid reopening of transactions past and closed. So it was submitted during the arguments that if any retrospective effect were to be given, then perhaps even transactions past and closed would have been rendered vulnerable. So it was submitted that the issue of retrospectivity was quite irrelevant because this was a case of omission or repeal without any savings clause. What we've been arguing before several courts and the authorities lower is that there is no saving clause, and therefore the common law principle referred to earlier would apply in, you know, in all of these petitions. So I think that was very important aspect which must be now taken into consideration. All of these petitioners, and for those who are not before the court, must now write to the adjudicating authorities that these show cause notices must be dropped. Those petitioners who were directly in court must serve the copy of this order by saying that they were part of this petition also. But those who are not even part of this petition and they have these show cause notices must give detailed submission on Section 6, how it impacts them, when was the show cause notice issued, what is the relevant period, what amounts they have paid so far, and how and in what form it must be refunded to them. So these were the important aspects which were argued before Gujarat High Court. We are happy to address. If you have any questions, you can send these questions to us on our email ID, contact@rastogichambers.com. I repeat the email ID, contact, CONTACT, @rastogichambers.com. We are always excited to argue these important matters which set the tone for industry. We want to thank GST Council and the Honorable Finance Minister who has taken keen interest in resolving these issues for the Indian exporters. The vision of our Prime Minister Modi is very clear to provide benefit to the Indian exporters. Decisions like this from Bombay High Court and Gujarat High Court and several other courts are continuously addressing these issues of Indian exporters. We feel that the right pragmatic approach to closure of these litigations in light of these deletions and omissions will now be settled. The revenue would not, challenge this before the Supreme Court, because if that happens, then it directly impacts or increases the cost of the Indian exporters. Do not forget to do like to this video and do subscribe to our YouTube channel for regular updates for the important cases related to taxes and other constitutional aspects which are argued and represented in the country by us. Thank you. Have a great day.